So, first about the CJ, who is, call it, under siege. 3 petitions, unprecedented. Normally it would be 1 petition or something of the sort for her removal. Let's begin from what becomes of the suits that have been filed in the Supreme Court and the pending injunction application to be moved on, Tuesday or Wednesday? What becomes of these processes now that the president has received consent from the Council of State and has forwarded the document she was seeking and for which the suits were instituted, and she has 10 days to file her preliminary response? What becomes of those suits?
Well, thank you for your question. I think they have become moot. The Supreme Court does not exist, or any other court does not exist to give deal in academic matters. So if the real life issues were that the procedure had been truncated and had not been properly followed, and as usual, the press had interviewed so many lawyers who have brought in their perspective, and the president appears to have listened to those perspectives and therefore rectified what it was that was looking that bad, and for what people were rushing to court has now been rectified. If you say that indeed the issues, the petitions ought to be referred to you for your inputs before the prima facie determination, that has now been done. So clearly, I believe that those cases have become moot.
Right. Is it, from what you have heard from the presidency, is it really a matter of the presidency now listening and forwarding the petitions, or it is a case of, a premature preemption on the part of both the plaintiffs in the suit and the Chief Justice, the Honorable Lady Chief Justice, who wrote to the presidency on the 27th asking for copies of these petitions?
Well, the Constitution guarantees the freedom of speech, and as you know, the press or the media exercise that freedom when these things appeared in the media. Yesterday, I was on one of your platforms, and I was saying that were those involved flying kites? Because they set up a panel for all of us, and we also who was going to be chairman, so and so and so. Again, even reading the law, they are not members of the committee. So what was all this? And the Chief Justice, I think, was right in saying that she has also read from the media the things that are going on. And if the thing concerns her, then she cannot keep mute. So I think the media somehow created the brouhaha by saying that the committee has already been set up and they are about to embark on the preliminary investigations.
I'm not sure there was any report about a committee being set up. The presidency's communication was that the president had forwarded the petitions to the Council of State for consultation, pursuant to Article 146, Clause 6, which commands the president to consult with the Council of State in determining, not really in determining, okay, let's say because of a J-Chung, to determine a prima facie before the committee will be set up. So therein comes the question that they wrote to the Council of State on the 24th. And the Council of State wrote back consenting to the president. They wrote to the Council of State actually asking and seeking consent that they were to commence the process. And if the Council of State would approve, they would forward the processes to the Chief Justice. The very day the Chief Justice wrote is the very day we are told that the Council of State wrote back giving the consent. And then the next day, it is forwarded to the Chief Justice.
Samson, I'm aware, you are very, very much aware about fake news. I think it's been one of your takes before. So I believe there was a lot of fake news all over the place about the committee having been set up with the former Chief Justice of Akufu, Betimo, Idrisu, all kinds of names. And these were flying all over the
Sophia
place.
Akufu is member of the Council of State. Betty Mulder-Drisu is member of the Council of State. They are disqualified from being members. I'm
saying so. And yet these news items were all over the place. The committee, a 5-member committee has been set up with herself and the Betty Mulder, people who are even supposed to be members of the Council of State. So I am not surprised. I mean, were you not in this country when we heard that Senator Rawlings had already been given a post, only for facie to come out to say that nothing of the sort exists. Okay. And they were all on government letterhead, Office of the President, announcing appointments. They turned out not to be true.
Okay.
You get my drift. So I think fake news fed into everything, and then it made people to become a little jittery about it.
The president said he was...
It was...
The president said he was disappointed in the Chief Justice for publicizing her letter to, the council and to him and the council, and also copying, persons or entities who were not supposed to be part of this in-camera process. The law says the process, all proceedings must be in camera. So if you copy people who are not part of this process, you are rather, breaching the in-camera rule. What do you say?
Well, she was only asking for copies of the petition to be given to him. What I understand the law to be saying is that the petition should never come into the public domain because people respect the judiciary, and if you scandalize the judiciary on points which are not true, only for them to turn out to be untrue indeed, then people might have formed impressions about the judiciary already. So do not publish the petition. I don't think that was what she was doing. She was only asking that copies be sent to her.
All right. So this debate about prima facie, is the CJ entitled to a prima facie determination, entitled to be asked to bring a comment or response for the prima facie determination, and when should that actually happen?
Well, if you have not heard the view of the person you are going to investigate, what kind of investigations are you going to set up for yourself? It's only fair that you hear from both sides and then try to find out where is the prima facie case. I mean, perhaps the person who is filing this petition may not have insights into the allegations that is making against the Chief Justice that maybe is authorized by the Constitution or by any other law to act in a certain manner. And then he believes that the act itself amounts to a stated misbehavior or something. Again, the rules are quite clear that the justice of the Superior Court or a chairman of the regional shall not be removed from office except for stated misbehavior or incompetence or on ground of inability to perform the functions of his office arising from infirmity of body or mind. This is the golden rule. This is the standard that you are to follow. So whatever it is that somebody is saying, let me also find out whether in fact he has brought evidence to show that I have misbehaved in a certain manner, I'm incompetent in a certain manner, or although I'm fit, well, and kicking, I'm still not that well as a result of infirmity of body or mind. So if you don't show these things to me for me to respond, how would you then make a determination that the prima facie case has been made against me? And it's not only that, but the Ayikoi and the Tiger Eye Dairy cases all point to saying the same thing. It's only fair. I mean, it's like saying common sense arising from natural justice that you're going to make a decision against somebody. That person is entitled to be heard. And just show me the petition. Let me see what the people are saying. Let me respond to them. That when I did this because I'm authorized by law as the head of the judiciary to take a certain step. And that is all I did in accordance with the Constitution. It's like saying you should not empanel the panel that would hear the matter because you are interested. And the law is that Whether you are interested or not, it is your duty imposed on you by the Constitution to perform that duty. So you must. So those who have made the petition against it, what are the grounds for which they have made the decision? And if she has a say, a defense to show that, in fact, she has not indulged in any of the things they are talking about, why not?
You say that cardinal principle of law that if you don't hear her side, how do you do the investigation? How do you investigate her without her side? That's your point, right?
That's it.
Is it the Council of State and the President who do the investigation, or it is the committee, when it is set up, that does the investigation?
If we want to go by the Tiger Eye one, Dairy one, what they are saying is that to determine whether there's a prima facie that a judge should be removed, you should give the judge a hearing. Give the judge a hearing. In other words, let her make an input into this prima facie thing that you intend to do. In other words, the president alone, some say is only a mere conveyor belt that he sends the thing. But if you read the section well, he is involved in taking that decision as to whether or not there must be a prima facie case.
Yeah, when the petition involves the CJ. But when the petition does not involve the CJ, he's actually a conveyor belt.
Exactly. He's also involved, yeah. Mm-hmm.
So my question to you was, is it the committee that investigates, or is the prima facie process that does investigation?
You see, those two steps are not very, very clear in my view. The three-member committee must have to investigate to find out whether there is a prima facie case. The prima facie case does not.
There's no a committee that does the prima facie. The president, in consultation with the Council of State.
Yes.
It is when a prima facie is established, then a 5-member committee is set up to do the investigation. Is that correct, sir?
That's why I'm saying that issue must have to be clarified well. And now we are doing a constitutional review. So I think we should clarify that aspect very, very well. Otherwise, like it was said in the Ajetum thing, the president can decide if he is to determine who, looking at the word, where the petition is for the removal of the Chief Justice, the president shall, acting in consultation with the Council of State, appoint a committee consisting of 2 justices of the Supreme Court, one of whom shall be appointed chairman by the president, and 3 other persons who are not members of the Council of State, nor members of Parliament, nor lawyers. So looking at the first part, where the petition is for the removal of the Chief Justice, the president shall, acting in consultation with the Council of State, appoint a committee consisting of 2 justices of the Supreme Court, one of whom shall be appointed chairman. What does it mean? That once he receives it, then he can appoint the committee. That seems
prima facie. Prima facie, in other words, is to determine whether someone has a case to answer. Is that correct?
That is what comes under 7. The committee appointed shall inquire into the petition, recommend to the president whether the...
No, sir, this is my question. My question is prima facie. We want to assist our audiences. When we say prima facie, are we at this point trying to establish whether the accused has a case to answer? Is that what we are trying to do?
That is the point. Has he got any case to answer at all? That's prima facie.
So if that is correct, help us appreciate this. You've done many years of practice, including in criminal practice. Like we do in the committal proceedings. When is the accused invited to answer a case?
You mean when it is an indictment?
Correct.
When the case is on indictment. It's only after you have finished with the preliminary issues that you decide whether or not there is a prima facie case.
So The prima facie,
magistrate, the circuit, the lower court will have to go through that process to determine whether there's a prima facie case or not.
right. So that's a question I want to know from you. If you apply that principle, should the one the petition is against be called to give an opinion or response before the prima facie determination is done?
I think in both Ayikoi and the Tiger Eye, what they are saying is that whenever you do some prima facie evidence, because you are going to investigate whether there is prima facie or not, remember that all the evidence of the statements and whatever it is in the indictable matter are put before the magistrate or the circuit court, especially the magistrate, to look at. So there will be evidence before them. Statements, whatever it is, to form that prima facie case to decide whether or not the case should go to trial. Isn't it?
Yes.
So if you have not heard anything, if you have nothing from the other side,
right,
what are you determining? How could you come to a conclusion that you think there is prima facie matter to go to trial? Okay.
So, like the example I gave, I want us to use that to see if we can help properly people understand. At the magistrate court, if you are doing the committal, the authorities are clear that once the magistrate finds that there is a scintilla of evidence, even without hearing the other side, they must commit. That's the authority established.
I'm saying that in that case, there's something before the magistrate, isn't it?
What is before the magistrate at this point?
The statements and whatever it is of everybody involved in determining, the prosecution witnesses, whatever. You have a whole a bill of indictment, right, which is telling you where you are. And is the accused statement not part of the bill of indictment?
Correct.
Yes, you have everything before you. In this case, why do you want to deny the Chief Justice, whose conduct you are going to determine, the opportunity to tell you in reaction to some of the things you have, to enable you decide whether or not the thing itself is frivolous? Because it's a very good position to adopt, in the sense that otherwise everybody can file, and these were all discussed in the Ayikoi, that anybody can just get up to file a petition against a Chief Justice. And in fact, the worst part is where it is said that where a petition has been referred to the committee under this article, the President may, in the case of Chief Justice, acting according to the advice of the council by warrant, signed by suspend the Chief Justice. Yeah,
before we get there, again, so the trial matter, the criminal process I'm trying to use as an example, I'll ask one or two more questions on that briefly so that we can proceed. You can charge an accused to court without a statement from them. Is that correct?
Yes.
Okay. And when we say prima facie in law, when lawyers say prima facie, and even when the law itself, like if you took the Copyright Act or intellectual property, they say registration is prima facie evidence of ownership, correct?
Yes.
Do you need to investigate before you can say it is prima facie evidence of ownership?
The point I would like to make to you is that so long as these matters have gone before the Supreme Court, which have received interpretation, I do not think that we should go on the general, but rather zoom in on what we know. That Ayikoi has made that point, that it is not fair to try and determine a prima facie case without giving the person a hearing.
Ayikoi as a ratio, as an orbiter. Utaderi as an orbiter or as a ratio?
Whether it is orbiter or ratio, they make good points.
Therefore, here tells me that it was orbiter and not ratio.
Matter. For me, it does not matter.
No, we are educating our people too. What do we follow? When we say the Supreme Court has done something and it is binding, what is binding? Is it ratio or orbiter?
Well, as a lawyer, you will say that it should be the ratio decidendi of the matter.
Exactly. Obita is not
as
binding.
Lawyers. But I'm saying that when the Supreme Court, the highest court of the land, has given a direction, then let us look at it this way, because it's only fair. It is only fair to the person. I don't think we should ignore it completely. Okay. To say that that was not what the case decided, so just forget about it.
Okay. I'll get to this with my guests, but I said I'll ask two questions about that. One more question about that, because last night I was reading Section 19 of the Evidence Act, Act 323, and it defined what prima facie evidence is, and it says that it's evidence of a fact that creates a rebuttable presumption. And then at Section 20, it says rebuttable presumption imposes a burden to produce evidence, So if prima facie is a rebuttable presumption, when you invite a response, have you not already rebutted the presumption at the beginning, even before the investigation?
And I'm saying that to avoid frivolous petitions being sent about chief justices and other Superior Court judges, these laws have been put in place to ensure that you do not permit an abuse of that process, like anybody saying that, as for you, I will have you removed by all means, and I'll file the petition to somebody. So the Supreme Court is saying, give that person, allow that person to be heard, give her something for you in even the determination of the prima facie case.
If the prima facie is to determine something which is inconclusive, something which is just a presumption, and then you invite a reaction, and the reaction deals with the matter and exhausts it, have you actually not turned the constitutional provision on its head that one step, there are three steps. One step is to make a prima facie determination, and another entity is supposed to do an investigation. Then in the prima facie, those doing the prima facie, would they not have acted ultra vires their power, which is not to investigate, but only determine prima facie?
I don't think so, because with the adjectum and the rest, it is not only the letter of the Constitution you are looking at, but the spirit behind all those things should come in to help you to do your interpretation. So don't just go to the literal word, but proposing. Why are we saying that everything should be in camera? Why are we saying that? Is it not to protect the image of the judiciary? And secondly, why do we talk about prima facie? If the thing is frivolous, just dismiss it.
Okay.
And don't disturb the Chief Justice going ahead and even suspending.
All right. So